All right, let's look at some of the questions that we had over the break. One of the questions said, if we report something to social services, are we assured confidentiality? It's supposed to be, but I too have heard that the parents sometimes know where it comes from. If, however, you go through the principal's office and we have ways to report it from the school, hopefully without identifying you, so we can work with you to try to enhance your anonymity. But that's correct. Let me just clearly point this out. I cannot promise you anything other than our best efforts, but I can tell you this: as mandatory reporters, things of that sort, we have to make reports if we think the child's safety or mental or physical well-being is being jeopardized. So we will do the best we can, but I too have heard the same rumors as was put out in this question. We'll do the best that we can. I want to clarify that your email addresses, I'm not talking about Yahoo and Gmail and all that stuff. I'm talking about your school email accounts or public records, the ones with the Caldwell EDU on them. The stuff that you're talking about there would be subject to a public records request. What about getting students from the office to the teacher's classroom if there are locked doors in between there, since we have to lock them, or if we ask to send a kid to the office? The first thing is, it depends on the age of the kid. A principal is not going or should not ask a teacher just to send a pre-K student to the office unless it's pretty close, unattended. Or a kid that has a track record of being a runner, or being someone that you can't trust to get where they're supposed to be going. If we have that situation, or if we have locked doors in between, some other teacher, the school secretary, the assistant principal can be utilized. So don't get all upset about this. If you're having that problem, sit down with your principal. I talked with the superintendent during the break. We can make arrangements to appease the situation. So if we're dealing with older kids, they can be trusted usually to go where they're directed to go. And if they don't get there, they would certainly be subject to punishment. Now, what you want to resist is the kid saying, well, so-and-so, can they go with me? I want them to go with me to such place. That would pose a problem. We have 2 or 3 cases now where kids slip off campus when they're supposed to be going somewhere. They take their buddy with them. We've had car wrecks, and unfortunately we have a death claim in certain areas now where that happened. Teachers don't send kids on missions for you. Sometimes you hear, hey, can you run up to such and such and get me a Sonic drink or a McDonald's burger or so-and-so? When you do that, you're jeopardizing your job. All this immunity and all this is going to be out the window, because that's not the course of scope of your employment. Those kids will be deemed to be on a mission for you personally. So they, in effect, will be like your own kids. And if they get injured or if they injure someone else, everybody's going to be looking at you personally in addition to the school district. So do not use kids as your messengers, your couriers off campus. That can certainly get you in the school district in some trouble. You are coming to a school and there's an inventory list. You're new to the district, or it's a new school year, and something is not on that inventory. You need to make a notation that the item is either missing or it's not in your classroom before you sign that inventory. Have that discussion with your principal before you sign that inventory. Checkout procedures. What we need to stress as principals to our parents is that we are only going to allow the child to be released to you and to the persons who you authorize us to release the child to. There will be no exception. We have a case out of Evangeline Parish down in that area, maybe it was Allen Parish, where a person came and checked out a kid and went straight to Texas. And the kid was not heard from again. There were allegations that the kid had been sexually abused in Texas. So a big lawsuit resulted from that. So we as a school district are not going to allow people to check out kids unless they are the parent or legal guardian with papers, or if the parents have expressly authorized that person to check the kid out. Now, we know that things change. Sometimes the parent comes in at the beginning of the year and says, A, B, and C can check my child out. But she has a falling out with B. And she's thinking in her head, well, I don't want B to get him, but it never comes up at school and changes that form. Our form needs to say where they signed it, we will honor this directive and authorization until such time as you change it in writing. So you need to do that, principals, to protect yourselves and ourselves. Teachers, please be aware that we don't allow KNOE or any of these companies, news agencies to come on campus and take pictures of kids and put them on the news without written parental permission. There are segments of our society out there where people are looking for kids. Maybe they're from a strange family or something like that. Kids may, when I say witness protection list, that's just my way of saying that there may be a person that is a danger to a child that does not know where the child is, and then their story airs without anyone's permission. And it's obviously that child is at such elementary school. There's all types of reasons we do not allow the media to film our kids without the parents' permission. I start with that because hopefully you understand the importance of that the same reasons prohibit you as teachers from taking pictures of your students and posting them on Facebook without the parents' permission. So the general rule is that if there's going to be any photographs taken of a kid, then we need parental permission before those are publicized, either by the news or on anyone's Facebook accounts. I wanted to call that to your attention. The finances. If you are responsible for finances, either as the school bookkeeper or someone who has a club or an organization where you take up money, I want to give you some points, and I haven't even talked with Lauren. I've spoken with her about this, but we do not want you to keep cash on hand. You need to make deposits daily. Okay? Money has a way of walking. If any of you are dads or moms with daughters, you know what I'm talking about. I can go to bed with a $20 bill in my wallet, and when I leave the house and make an order at Starbucks, I'll be financially embarrassed. So I have learned before I go in there to look at my wallet. Okay? Money does walk. And it's a situation where a school district lives on the trust that our public puts into us. And so if we have a situation where money is stolen and things of that nature, then we run the risk of having our voters say, we can't trust you with money because you're not good guardians of that which we give you. But if you go losing a bunch of fundraiser money or a bunch of uniform money, it can have a lot of repercussions. And a lot of them will come back to roost with the person that had them. So be particularly mindful of those cash that you have on hand and how to safeguard those. Also, use of schools. We have insurance that governs and covers all school events. So if we're having a basketball game at home, our insurance policy covers that. If we're having school, our insurance policy is going to cover that. If we're having band practice, we don't have a coverage problem. The issue you have is that when we lease out or rent out our school buildings, or if we just let such and such family use it for a family reunion, the problem that we run into there is it has nothing to do with the operation of the schools. And I would think that we would have insurance coverage, but it's going to turn on whether we had granted permission and had approved the use of that school facility. So for that reason, it's not busy work. We ask our schools to complete facility use agreements, facility use leases. We do that for an express purpose. We also ask that these people pay us in the form of cleanup deposit or utilities deposit. For those districts that do allow the outside use of their facilities, they shouldn't go in the hole outside. We shouldn't have to bring in our hardworking custodians to clean up someone else's trash. And the school board's going to have to pay for that. We should not allow for the risk of injury if the company or group or family that is utilizing it can't put up an insurance policy. These special event insurance policies are less than $300 to $500. Okay, so if you're having some type of program at our school, certainly of that magnitude that you use this room or gymnasium, you could pitch in a little bit to get that policy of insurance. We also ought to be mindful of the need for security. If they're going to utilize our facility for large groups, maybe we want to require them to have security there, have at least one off-duty officer there. Some districts do not allow their facilities to be used for commercial gain. Like, we're not going to lease out our gym for a concert in which money is charged to get in. That is an individual board decision as to whether they do that. Many do not. Another question I got. Hey, I worked in Catahoula Parish, and I was a tenured teacher there. And I moved over to Caldwell, and I still tenured. The answer to that is no. You acquire tenure in each particular parish. So once you acquire tenure, it's not like a status that follows you around the state. Tenure in each particular parish. And now we know that with Act 1 that you have to be highly effective for 5 out of 6 years before you can. Last week I terminated a teacher in a particular parish. She had been employed there since 2014. She had been employed there since 2010, but she was not tenured. The new law went into effect in 12, so she didn't have her 3 years in. By the time Act 1 went in 12, she only had 2. So even though she'd been there for over 6 years, she had still not tenured. So tenure is based on your evaluations, and you don't compare. If a child is expelled from one parish, they can't just pick up their toys and go and enroll in another parish. They have to be admitted by that new school board. Most school boards will not admit a child that's been expelled from one district. And that's one of the reasons why I tell districts to go ahead with an expulsion hearing until such time as the child tries to withdraw. Because if every district will hold the parents' feet to the fires, that will cut down the number of district hopping, that it goes on. Personally, I think that if a child had been recommended for expulsion in one parish, the superintendent is within his rights not to admit the child into his or her parish due to that pending expulsion over there. Because we don't want one parish's problem just to hop around parish to parish. Now, we have heard that parents call people in and say, look, we're going to expel you. If we expel you, you can't go to Caldwell. If you withdraw now, you go there in. So that goes on. It's a round world too. I think that a group of superintendents that work around this parish, knowing them as I do, they have meetings too. Superintendents have superintendent meetings. So as they build relationships, I think there's less tendency to do that. So that's something that's good. But I wanted to point out that you're expelled in one district, cannot hop in and go to another school in another. Parents being banned from schools. What do we do if we have a parent that threatens, curses, and just goes extremely over the top? He tries to swing at teachers and stuff like that. We can ban those types of parents from campus for a particular period of time. The cases that are out there suggest that the principal should deal with the parent first. The parent should get a warning if it's obviously if they do something just super stupid, like get a shove or do something that is egregious. We ban them immediately. But if it's just a pattern that we see to be escalated, we send them a warning the first time, tell them that the conduct they exhibited on such and such date, for instance, the 29th is unacceptable, that if it happens again, they'll be banned. So that if they are actually banned, the letter comes from the principal and it ends, if you not agree with this decision, you may consult the superintendent. The courts seem to like giving them, the parents, at least one opportunity to go above the principal level. If we start with the superintendent, then that means the next level they would have to would be hop to the board. I know that boards around the state don't necessarily get into that game. So if we start with the principal, we give them the one level of review to the superintendent. And that's the way that that can go. All right. I think that answers all the questions that we had. I want to talk now about something that I put off to the end because, number one, it's a good way to start a presentation about terminating people. Okay? But, I've always said that I don't think there's any topics that we should stay away from the training. I think the purpose of the training is hopefully to raise our level of performance and let us know how we treat people fairly. So we're going to start with our non-certificated people, and we're going to move all the way up to superintendents. And so in the realm of employee discipline, all the rules were turned topsy-turvy in 2012. Before 2012, teacher tenure and employment of the employees had been the same for almost 100 years in Louisiana. There were cases back in the 1920s talking about automatic tenure after 3 years. In 2012, they changed them dramatically. For those of you that may not remember this, the superintendent would make a termination decision on a tenured teacher. The teacher could appoint a person to a 3-person panel, the superintendent could, and the principal could. So a 3-person panel was going to hear the appeal. The principal got to pick one, the superintendent got to pick one, and the teacher got to pick one. But how do you think that one was going to go? And then, after that 3-person panel heard the evidence, they could only make a written recommendation back to the superintendent. The superintendent could ignore that recommendation. No, I fired them once. They're still fired. So that's what happened in 2012. Well, in 2014, they realized that they'd gone from here way over to here, and they brought the pendulum back into the middle. So we're going to talk about that. I just want you to know that everything turned topsy-turvy in 2012. So with our support employees, the support employee law simply says those employees who do not acquire tenure may be terminated in accordance with board policy. That is all it says. So you have to look at board policy to determine what your rights are and what the obligations are of the administration. Caldwell Parish, that policy is GBR. That's the GBN, GBN, employee terminations. And I think it basically says terminations have to be made by the superintendent. The employee does not get a hearing before the board. So there's GBN for support employees. It's everywhere from school secretaries, paras, food service, custodial, maintenance, right on up. Bus aides, those will be your support employees and your non-certificated employees. The next one is our non-tenured teachers. There'll be many, many, many of the teachers that are in this room. And the law there says that a non-tenured teacher may be dismissed for valid reasons. Valid reasons. One day I didn't know what a valid reason was, so I looked it up and I found a case that defined a valid reason. It said a valid reason is a sound and sufficient reason. What in the heck is that? Valid versus sound and sufficient. But when you read the case, what it says is that we just are not going to allow you to terminate a non-tenured teacher because you don't like it. There's got to be something that deals with their performance. It doesn't have to rise to the level of being dishonesty, willful neglect of duty, incompetency like it would for a tenured teacher. But as long as there's some valid performance-based issue, they are subject to termination. But how are they subject to termination? The way that works is a non-tenured teacher receives a letter from the superintendent. It says, "Dear Mr. Geis, I'm contemplating disciplinary action against you, which may include your termination based upon the following reasons. Number one, you've not turned in lesson plans for the past 2 weeks. Number two, you've not been on duty when directed to do so by the principal. Number three, whatever it is, the superintendent lists those out. That you, as the non-tenured teacher, have 7 days, 7 calendar days, not school days, but 7 calendar days to respond to the superintendent and tell your Paul Harvey, your side of the story, okay, the rest of the story. And then the superintendent reads and reviews your response and then makes his decision. Here's the end. If you wish to appeal that decision, you only have 60 days to appeal it to the district court. It's a very hard burden. You have to prove that there was no evidence that you've done anything that you're accused of. Since there's no evidence, the superintendent was just being arbitrary because there was no evidence to support it. That's the way it works for a non-tenured teacher. For a tenured teacher, they get a lot more rights. Instead of a 7-day letter, they get a 10-day letter. Okay? So if you've been highly successful, highly effective, for 5 out of 6 years, you have tenure, or if you had already acquired tenure when the new law came into effect, you still retain it. And you may only be terminated on the grounds of specific charges. 1, dishonesty. 2, incompetency. 3, willful neglect of duty. 4, poor performance. Okay? And there's some other little ones like immorality, but immorality is not like prostitution, stripping on the pole at the club, public drunkenness. None of that's immorality. Immorality is conviction of very specific crimes, usually sex crimes. And folks, let's look at it this way. You get convicted of that, State Department of Education is going to yank your license, so your termination with the school board is the last thing you're worried about. Okay? So the big 3 are going to be dishonesty, incompetency, and neglect of duty, poor performance. So let's talk about those for a second. Dishonesty is clear. Not telling the truth, taking a sick leave day. Facebook shows you were late on the beach, taking money that should have been deposited. And Facebook is a larger screen. I had this lady that was claiming a back accident, and she had posted some pictures of herself planking. Y'all know what planking is? She pulled up at Sonic, crawled out the window of her car, Dukes of Hazzard style. Didn't open the door, crawled out the window. You got a little red shelf where you put your stuff? She stretched out like Superman on that thing. Was able to balance her body perfectly straight. Private investigator had a picture of her on a flat screen TV where she was planked up on top of that flat screen TV. Now she was saying she had a bad back. Folks, I've had a bad back. That is not a bad back. So that case got some dismissal for purposes of fraud. But that would be dishonesty as well. Saying you're sick when you're not and get caught. But money is the big situation on dishonesty. So dishonesty. Incompetency. That is the pure inability to teach the subject matter or the inability to maintain classroom management control. Now, if your principal comes down there and says, look, we want to try to remediate you and offer you intensive assistance, please do not reject that offer. Intensive assistance is just that. It is insistence to try to help you overcome the problem. I had a hearing about 2 months ago where we had offered to place a teacher that was having some classroom management control issues on intensive assistance. She just rejected it. She said, I'm not, you're just here to fire me, and I'm not doing that. She did get fired, and the hearing officer that heard it ultimately concluded that as well. But intensive assistance is only offered if you are alleged to be incompetent. The final area of termination for a tenured teacher, the big one, is neglect of duty. That's not doing your job description. That's not following your contract. You're not getting to school on time. You're leaving early. You're not supervising kids. You're not turning in your lesson plans. know, just you're cursing, you're using profanity, you're having inappropriate contact with students, all of those would be neglect of duty situations. It does not require remediation. You know, if we have a teacher who's incompetent, we may say, look, go down and watch so-and-so at this school, watch how they teach, come back and implement that in your classroom. That's the type of stuff we do with remediation and intensive assistance. But if you curse out the principal, drop the F-bomb on your principal, or if you steal money from the school, we don't have to say, now look, next time, don't steal money from us, okay? Or don't curse your principal. There's no remediation required, no second chance required for that type of misconduct. So that's the grounds for terminating your tenured teacher. Let's talk about the procedure. You know, on the non-tenured, we said they got a 7-day letter and a chance to respond. The tenured teacher, it's a 10-day letter and a chance to respond. But if they don't like the superintendent's decision, they have a right to ask for a hearing within 10 days. And we have a list of hearing officers. The superintendent reaches in a box or hat, pulls out the name of the hearing officer, and the tenured teacher would get a hearing before that hearing officer. And the superintendent would say, Mr. Hearing Officer, I reached the decision we need to terminate Mr. Geis, and here's my evidence. He will call witnesses and introduce documents. The teacher will call witnesses on his or her behalf and introduce documents. But it's very similar to what we talked about earlier. That hearing officer can't say, you know what, I wouldn't have terminated this teacher, I would have done this. Nope. If the hearing officer finds any evidence in support of the guilt of that teacher, he has to or she has to affirm the decision of the superintendent. I had that very same thing in the case that I had with the lady. I told you I had a lady that just said, I'm not doing intensive assistance. And we terminated her. And the hearing officer put in his opinion. Had I been the superintendent, I would not have terminated her. I would have given her another warning and told her that told her again that she had to do intensive assistance. He said, however, that is not my role. As a hearing officer, my job is to determine if there was any evidence of guilt. And in this situation, the teacher wrote on there, I will not do it and signed it. That was willful neglect of duty. And she did not address her incompetency. So although I would not have terminated, the superintendent was well within his rights to have done so. So again, if there's any evidence to support that decision, then the decision is to be affirmed. The next level of the food chain are our supervisors, our assistant principals and principals. Up until 2014, they had the right to a hearing before the school board. And in 2014, they changed it with one little sentence. Anybody above classroom teacher whose termination is sought may be terminated in accordance with the same procedure as utilized for a tenured teacher. So principals, assistant principals, supervisors now are subject to termination by the superintendent, subject to the right of the 10-day letter and the right to the hearing before the disciplinary hearing officer. Then next are our bus drivers. Until May of 2018, our bus operators could be terminated only by the board. But they got y'all too this year. Effective July 1, bus operators are now subject to termination by the superintendent with a 10-day letter, but they too have the right to a hearing before the disciplinary hearing officer. And then finally, your superintendent. Superintendent is subject to termination by a vote of the board. Certain specific charges of contract or competence. I think I've hit every one of the categories. So the law has really changed. Everything used to come through the school board. Now everything comes through superintendent. Now, as I'm talking, I reminded myself of a couple of things. First, I forgot to tell you that even substitute teachers have to go through the background check. And if they have a felony conviction, they can't be hired. That's the first thing I want to tell you. The second thing I want to tell you is that grievance procedure. We've had some employees, when they want to file a grievance saying the superintendent is recommended by termination, the courts have said, look, the school board is no longer in the process of terminating the hiring. So you can't file a grievance to take to the board a decision of the superintendent terminating, because the board has no authority to reverse the superintendent for termination issue. So you can't file a grievance on a termination situation. All right. I think I've covered that. Question? Folks, I'm going to stick around for about 10 minutes. I'm going to answer any questions you've got. I want to apologize to you that I'm not the PowerPointer, technology person that all your other presenters are. But I hope you can at least appreciate the fact that I don't get up here and read to you. I will answer any questions that you've got. I'll stick around here because many people don't like to ask questions in front of other people. So if you got any questions, come on up here. I hope you all have a great, I know we got the holidays coming up, Thanksgiving, Christmas. I hope you all have a great holiday season, a great rest of the year. Thank you for what you do. Oh yeah, I'm going to tell you, we've got a sheet, where you signed in. Please be sure to sign out.
I was just going to remind y'all that I was looking for a microphone. Seems to have it. So before you leave here, make sure you sign out. Otherwise, we're going to have an issue we don't need to have when it comes